For those of you that don't know me, I am Elise Fox. I'm the chair of the board of directors for the South Carolina Solar Council. Traditionally, well, today was when we had originally planned to have our spring meeting, but we were unable to have that meeting, obviously, because of COVID-19. So this is the first time that we have done a webinar. So I appreciate you joining us, and we hope that you'll find it interesting and useful. So our awards, which are normally held in the spring, have been pushed to the fall meeting. We don't have details on that yet, but we're hoping that we'll all be able to get together in the fall. I want you to note that we are recording this webinar because we want to post it to our website, so just keep that in mind. A couple of things too, I want to thank Grant Schaefer and South Coast Solar. They are hosting us for this meeting, which enables us to bring all of us together. I also want to bring your attention to, we have a new intern from Coastal Carolina University. Her name is Mallory Panuelo, and she's been doing a fantastic job with our social media. So she's been very active on Facebook, and she just started an Instagram account for us. So I would like to encourage you to like those and follow those if you're not already, and please share the information to help us reach new contacts. Couple of logistical things. Everyone who is joining should be muted. We ask that you keep yourself muted during the presentations. If you have a question at the end of each speaker, our first speaker is going to be Kelly Rainsford from the SC Consumer Protection Bureau. We'll do raise your hand. So if you scroll down and look at the bottom of your screen, if you click on the tab that says participants, you'll notice that there's a little button that says raise your hand. So I'm going to do it right now for myself so you see. So I click raise my hand, and then a little blue hand shows up in the chat box next to participants and also on my picture. And that's how the speaker will know that you have a question. And then they will call on you. When they call on you, you can unmute yourself to ask your question, and then please mute yourself back again. And after you've been called on for your question, just lower your hand and it'll take it off the screen so that we know that it's lowered. So we are going to start with our first speaker, Kelly Rainsford, who's from the SC Consumer Protection Bureau. This was one of our more popular talks that we had in a long time when they spoke to us last spring. We had Jim Copeland and Carrie Gruber. I can't remember. Liebarger. Yeah, Gruby Liebarger. Yes. Thank you. Spoke to us last spring, and everyone really, really enjoyed the presentation. We got lots of great feedback. So we are happy to share it, have them back with us again today. And for that, I'm going to turn it over to Kelly.
Thank you so much. I appreciate it. All that build up, hopefully I can live up to it. I'm going to go ahead and share my screen. Let me make sure I share the right one. I believe. Do you see my PowerPoint?
Not yet.
Can you see it?
No, not yet.
Let's see.
All right, it's starting.
Okay, great. All right. All right, good morning. As Elise said, I am Kelly Rainsford. I am a Deputy Administrator and General Counsel here at the Department of Consumer Affairs. My boss is Carrie Gruby Liebarger, who is the Administrator and Consumer Advocate for South Carolina. And Jim Copeland is my Chief Enforcement Attorney, and they both, as Elise said, they both attended last year and did a presentation. Mine's going to be a little different this year because we have our regulation that we issued, a proposed regulation that was published in the State Register this year, actually in February, I believe it was. So we're going to kind of talk about that and a lot of the things that we've learned during this process and consumer protections we've tried to implement through the proposed regulation. So I'll go ahead and get started. I'm a lawyer, so obviously I'm going to have a disclaimer every time we do a presentation. This is not meant to substitute for actually consulting with an attorney or looking at the laws and reading them yourself. Very quick, the department, the South Carolina Department of Consumer Affairs is the state's consumer protection agency. We began operations in 1975, and We've now been providing services for over 45 years, I guess. Our mission is to protect consumers from inequities in the marketplace through advocacy, mediation, enforcement, and education. So we will jump right in. Obviously, most of you are going to know that there are several moving parts in a solar transaction. And based on the review of our complaints, which I'll talk about in a minute, it appears that there are usually, even though not always, 4 parties that are involved in a typical solar transaction. You've got the salesman, the finance company, a solar company, and an installation company. The nature of the complaints that we see tend to lead you to believe that many consumers just don't realize how many different parties are actually involved whenever they enter into the contract for solar. So the complaints that we see from consumers, since 2014, the department has received 149 complaints against solar companies and their affiliates, all of the individuals involved in the transaction. We've seen 67 different businesses that we've had complaints against, that we've dealt with those complaints. And ultimately, we're able to get $720,000 to be refunded or adjusted for consumers as a result of the complaints that they filed with our office related to the solar transactions. The most common issue that we see or theme that recurs in all of the complaints is allegations of misleading or deceptive acts and practices. That includes misrepresentations that a future utility bill will be reduced because they've installed a solar facility of some sort, or misrepresentations regarding any rebates or incentives that allegedly would offset the cost of the installation. Receiving different or less panels than they had originally contracted for. And then failure of the solar company to provide paperwork. So as we kind of focused on these 4 most common issues and the overarching umbrella of the misleading and deceptive practices, we took that as we delved into regulating or issuing the proposed regulation. So as you know, the solar industry is regulated at not only the federal and state, but also the local level. And there are a lot of different laws that are applicable. The federal laws include, the Trade Commission Act, the Consumer Leasing Act, Truth in Lending, Unfair Deceptive Acts and Practices. And then you have all the different areas where the issues occur. So you've got the finance area, the construction and electrical, and then the advertising and marketing. At the state level in South Carolina, the Consumer Protection Code actually applies to a lot of these transactions currently. Title 37 contains the credit sales chapter in Chapter 2. And this specifically addresses home solicitation sales, which a lot of the, obviously a lot of the time whenever solar panels are contracted for, it's through a home solicitation. So that actually applies specifically in those transactions. And then we've got the consumer leases, Chapter 2 as well, and that applies to those. And then we have consumer loans, which is in Chapter 3 of Title 37. If a lender wants to charge more than 12% for a loan to fund or finance a solar transaction, then they have to be registered or licensed as a supervised lender with the South Carolina Board of Financial Institutions. And then we also have advertising parameters that are, or requirements that are applicable under Title 37, Chapter 2, Section 304. And then we have other filings or registrations or requirements that are applicable under our credit grantor. If a lender or a lessor does over $150,000 in a year, they have to file a notification of offering credit with the South Carolina Department of Consumer Affairs. If they want to charge more than 18% to do a loan or financing a solar installation, then they have to file a maximum rate with our office as well. And then you have your truth in lending and unconscionability requirements that are applicable as well. So there are a lot of, currently there are a lot of laws that are in place that apply to solar transactions that a lot of consumers and even industry doesn't realize currently. And then we have our Unfair Trade Practices Act under Title 39 as well, that is enforced by the AG's office and can be enforced to a certain extent by our office whenever it's related to consumer goods and services. So as you know, in 2019, the General Assembly passed the Energy Freedom Act, and one section of this specifically directed our department and the Department of the Office of Regulatory Staff to develop consumer protections related to the sale and lease of solar transactions. So at a minimum, we are required to provide for appropriate disclosures for sellers and lessors. And they noted in the, or they actually pointed out in the statute that sellers currently have to comply with Title 37. So we've started that regulation process and we've actually made a lot of progress in that. December of 2019, we issued a notice of drafting. On January 9th, we held a public forum out at Archives in Columbia, and we had pretty decent attendance there of interested parties. On February 14th, we submitted a proposed regulation to the Legislative Council, and it was published in the State Register on February 28th. So that proposed regulation was put out there, and there was a 30-day comment period that ended on March 30th. And we did get several comments, but we didn't receive any requests for a hearing on that. Under the regulation process, if we had received a request for hearing by 25 individuals or any association or organization that has 25 members, then we would have had a hearing on the proposed regulation. So that regulation hearing was scheduled to occur at the Administrative Law Court on April 7th, but we did not receive any requests for hearing. We did receive some comments that I'm going to mention as I talk about the regulation, but that hearing was canceled, which kind of worked out given the COVID situation. So here's the document number of the regulation that the Department of Consumer Affairs issued. And it was supposed to address the consumer protections related to the sale or lease of the renewable energy facilities. As we were working on this, obviously we kept talking about solar and solar because that is the most common one that is involved in South Carolina right now, but it does apply to other renewable energy facilities as well. The Office of Regulatory Staff issued document number 4960, and they actually were charged with addressing the lease of renewable energy facilities, but then they also had some additional disclosures and processes that they put in their proposed regulation as well to deal with complaints and enforcement. So when we did the regulation, we kind of separated everything out into sections based on, again, the complaints that we see and that we hear about. So the first section that's substantive in the regulation is the marketing section, because this is where a lot of the problems begin. So one thing that we put in was that a written pamphlet has to be provided to a consumer to explain their rights and responsibilities. We were gonna develop that, and it has to be given to the consumer at the time that the solicitation occurs. And in addition to explaining the rights and responsibilities, it also was supposed to include contact information for the state agencies that administer or enforce Title 37, which would be the Department of Consumer Affairs, or Title 58, which would be the Office of Regulatory Staff. We also pointed out the lead generators, that they have a special section because we see this in a lot of other industries where lead generators, oftentimes the consumer is not aware or doesn't realize that this person doesn't work for a particular company. They're actually just trying to get my information and go sell it to companies that offer the service that I'm looking to contract for. So we wanted to make sure that consumers were clear and understood that, that this person that is generating this lead, that is making the solicitation, doesn't actually work for the solar company or the installer or something like that. So we wanted to make sure to specifically address them, that they have to notify the consumer that they are in fact a lead generator, and that this has to be included in all advertisements and solicitations. And then also that they're not the one providing the renewable energy facility or the services associated with it. And then that disclose that they're going to actually share the consumer's information with others who do offer those services, whether it's the installation, the maintenance, the servicing, or something like that. And then we had a general provision that no one involved should advertise in a false, deceptive, or misleading manner. And we specifically pointed out if the retailer or lead generator knows or should know that the consumer will not be able to fulfill the terms of the agreement, or they won't benefit from the agreement, that they can't advertise in such a way to make the consumer think that they would. So the majority of the complaints that we receive relating to the solar industry cite misleading or false information regarding the amount of money a consumer will save by switching from a traditional utility to solar. And states that have tackled this issue of estimating future utility rates have done so in a variety of ways. We kind of tried to address this in the written marketing materials, that it has to meet certain requirements. And there are certain formatting provisions. It's got to be legible font, has to be provided in the same language that the oral representations were made to the individual. It has to contain contact information for the individual that's making the solicitation. And if they make any reference to the price of the renewable energy facility, they have to also explain the total price that the consumer would pay, whether maintenance and repairs are included in the total price, the consumer's eligibility for tax credits or other incentives, and they have to describe the warranty guarantee of energy production of the system. One comment that we did receive about the consumer's eligibility for tax credits or incentives, one of the comments said that it was too generic, that they wanted more guidance on what that meant, that seemed to create more issues for consumer protection than it seemed to resolve. So that was something that we would take back and kind of look at that, see if there's a way to address that in a better manner. And then if any estimate of savings that a consumer might or potentially was projected to have, then they would have to provide additional disclosures about how they calculated those projected savings. So in the next section, we tried to address a standard agreement or the provision of a standard agreement. And we talked about the department working with the Office of Regulatory Staff on the lease agreements because that's under their purview. And then, but having a standardized contract. One of the comments that we received was that the National Renewable Energy Laboratories had actually created a contract at one point, and that it had taken, a 1.5 to 2 years to actually come up with that. So I think there was a question of whether or not this was a feasible or a possible task for the department and ORS to take on. So that's obviously something we can look at as well. But that was something that was pointed out, was this isn't going to be as easy as maybe we thought it would to come up with a standardized contract. And another comment that we received was, because you have the federal, the state, and the local laws that are applicable to solar contracts, that a lot of times the local level will have differences depending on where you are within the state, and that that they would have specific requirements that may not be addressed by a standard contract that we would generate. So they were saying, you know, would you provide us a safe harbor if it conflicts with what a local requirement might be? Or are you going to require us to use a contract that contradicts the local requirements or is not in compliance with local requirements? So that was something that we, you know, have taken into consideration and are going to discuss as well. So with that in mind, we did try to come up with something for standardized agreements and require those agreements to be given and that the person had to have a copy of the agreement no later than 7 calendar days before they signed off on it. And obviously what we were trying to address with that is our greatest concern is a lot of people feel rushed, pushed into signing this contract in, you know, the heat of sales, and that we wanted to require a cooling off period before they ever signed it. We were going to develop that standard agreement. And again, it has to include the contact information for everyone involved. So it would be the consumer, the retailer, the lead generator, installer, whoever it might be. And one of the comments that we got in the feedback was that you don't always know who all of those different parties are going to be at the time of the agreement. You might know the company, but you won't know the actual individual. So that was something else that we heard in feedback as well. And then we wanted to make sure that consumers understood where they could file complaints. And then the right of rescission, which we'll talk about shortly. And then again, the total price to be paid. And that's whether it's paid in full, financed, leased, and that includes any one-time fees. And then timing of installation to start and be completed. Because we've seen examples, you can see here, one start in 1 week, approximate completion date, 6 to 8 weeks. Then there's another one that's an actual example we've seen, you know, that we anticipate being done within 60 days, but this is, you know, the best estimate and subject to change. Or oftentimes there are agreements and there's no disclosure at all about when if anything would start or be completed. And again, if they provide an estimate of any savings that would be that could be realized by the consumer in the agreement, then they have to provide the material assumptions that they use to calculate that, what they base that on. And then we have 2 separate statements in all caps that would be required to be provided, that this is just a quote, that this is going to vary depending on your power provider, you know, various things like that. And then also the tax incentives. That there are certain factors that would come in about the tax incentives as well. And then the agreement would have to disclose warranties or guarantees of energy production. And then wood maintenance and repairs, are those included in the total price? And then another thing that we have seen, and a lot of states have seen this and tried to address, was consumers often don't realize that if it's a third-party owner of the solar panels or the fixtures, they oftentimes will make a fixture filing. So we want that to be clear in the agreement itself, whether or not there will be a fixture filing made, because that's going to affect the individual's or the consumer's ability to sell their house. And then, as always, we are concerned about protecting consumers' data. So we included something in there about that as well, that they would have to disclose how the consumer's data would be protected. And we required that a copy of the fully executed agreement must be provided to the consumer. So in South Carolina, as I said, a lot of state law already applies. Currently, most solar sales agreements are already subject to the 3-day right of rescission. The regulation actually provides additional contingencies. And we provided that the approval of the interconnection agreement between the retailer and the consumer's retail electric provider would set off a separate right of rescission. So if it was rejected by the retail electric provider, the consumer would have 7 days to rescind or amend that. And the same is true for a consumer's homeowners association. One comment that we did receive back about the 7 calendar days and also about making the right of rescission contingent on the retail electric provider approving is that this kind of gives a little too much power, I would say, to the electric provider to control the situation. That gives them the, if they were to delay in approving the interconnection agreement, then that would delay the whole transaction, and the consumers oftentimes get frustrated with that process and end up canceling because they can't get the approval through the electric provider. One suggestion that we had received was that maybe make it based on getting the building permits or something else outside of making it based on the retail electric provider. So that was some feedback we got as well. And then we required due diligence on behalf of the retailer, that the retailer cannot enter into a contract with a third-party servicer that they know is unlikely or should know that is unlikely to fulfill the contract. And then the retailer shall verify that the third-party servicer understands and is capable of complying with everything involved in the transaction. And then also construction or installation cannot begin until the retailer knows that the agreement will be approved by the electric provider and by any HOA that would be involved. We also had record keeping requirements to make sure that we could review any of the retailers or lead generators. And if they were engaged in entering agreements or soliciting any of the transactions, then they have to maintain books and records for at least 3 years. And this would include agreements with South Carolina residents, any solicitation materials that are used, and records of contacts with consumers, whether or not agreements were actually entered. And that it should include the contact information for anyone who received, requested, or contracted for leads or referrals. And then for electronic delivery, one complaint that we often get is that the individual says they never got a copy of the executed contract or the materials in general. Oftentimes these are submitted to them, but they email them to them instead of providing on paper. And a lot of individuals are not tech savvy. Maybe they have an email address, but they don't ever check it. And so we wanted to say, yes, you can do electronic delivery and that would suffice. But you've got to get the consumer to give prior consent. And the font and formatting requirements have to be reasonably similar so that they are legible. And then they would still be subject to the state's Uniform Electronic Transactions Act, and then the federal electronic signatures and Global and National Commerce Act. And finally, we provided for remedies for any violation of Title 37 or this regulation. And we have 2 different types of remedies. One is we can issue an administrative order, ordering the retailer or whomever to cease and desist operations. We can require them to return property or money received in violation of this title or the regulation. And we can require them to pay penalties up to $5,000 per violation. The other alternative, and sometimes we're able to do these on the same track or 2 different tracks, is we could bring a civil action in the Court of Common Pleas, preventing them from using prohibited practices going forward. We can reform contracts and even rescind contracts. And that's all in addition to other actions that we have available under Title 37. So the information about the regulation was on our website under the news advocacy page. And this is our website currently, so it's a little bit different. So I was going to show you just a couple things about what you can do on our website. You can file a complaint, get a license. Sorry, I was trying to, there. You can get a license, you can background a business. So that allows you to see if they have the licenses they're supposed to have and look for any complaints against them. You can report identity theft and scams, and you can request presentations. But we also have our COVID-19 resources. So this is a great resource for everything that's going on right now. We've put out some press releases, some great information on the COVID resources for both businesses and consumers. It's So I wanted to point that out while I was here. And then please connect with us if you're on social media. We're on YouTube, Facebook, and Twitter. And we provide publications for free to you and your groups. So feel free to contact us and ask us for any of these. And I tried to kind of hurry through that because it felt like I was taking a long time. I was going to see if I could see the participants. Maybe stop share. Okay. All right. So with that, hopefully that wasn't too fast or slow. Does anyone have any questions? I see Bonnie.
Yeah, Kelly, thanks so much. I appreciate the opportunity to ask a question. I'm on my neighborhood's homeowners association board, and I know y'all have begun to compile complaints filed against homeowners associations or management companies.
Mm-hmm.
I was on that database, which is of course separate from your solar activity. And what I wondered is, can you add something that would allow a consumer whose homeowners association rejects a solar application to make a complaint to you that then shows up on that HOA database? I think, I mean, as others on the webinar know, I mean, we have many different homeowners associations that interpret this many different ways. I mean, I have my own personal legal opinion that it's against public policy now for a homeowners association to absolutely prohibit solar panels based on the action that the legislature took both in 2014 and again in 2019. So if y'all could put something together that collects that, we can begin to see how often this is taking place, because there's no one place that coalesces all that information right now. And then if also the solar companies could be educated that that's where they could go to log this complaint, maybe as a collective interest group, we can keep an eye on that and really bring some good data to the legislature to try to tackle this a little bit more head on if necessary.
Okay, I will definitely take that. Yes. I don't see any other questions.
Okay, well, we'll give one last chance to ask Kelly a question. Opportunity to raise your hand. Oh,
Dan
I see one pop up.
Based on what the previous person just said, is it illegal for a homeowners association to flatly deny when to put up solar panels?
Yeah, so I'm an attorney licensed in the state of South Carolina, and I have my own personal opinion about this. I think my opinion, we can argue it both ways. Certainly, the covenants and deed restrictions that are contained in any neighborhood's development plan and recorded create a contract between the homeowner and the developer or the homeowners association. I personally believe, and I have said this for years, I've said it since 2014, that I would be glad to litigate a case on this subject. I believe that our legislature has spoken, and that as a matter of public policies, homeowners associations and courts are not able now to enforce those deed restrictions. If it's just a homeowners association rule, there's an even greater likelihood of success, in my opinion. But it is, I don't think you can say definitively it is, quote, illegal. I believe it is a matter that needs to be clarified once and for all through litigation or through the legislature. And we've been utterly unable to clarify it through the legislature based on pushback from the management companies who represent the homeowners associations primarily, and the attorneys who represent homeowners associations in terms of foreclosures and liens. It is a debatable subject, is I guess what I should say. But my personal opinion is that it's not something that, as a matter of public policy, can be prohibited anymore.
Thank you.
Okay, well, thank you very much, Kelly. I really appreciate that. I think it was a really helpful and interesting conversation. We do appreciate it. And with that, I'm going to turn it over to Bonnie for her portion of the discussion.
Thanks. I'm working on sharing my screen.
We see it.
And was I successful with that?
Yes, you were.
All right, great. Thank you. Thank you so much for the opportunity to be here, Elise. I really appreciate it. And as we shared before, I applaud you for moving forward with this event on the scheduled day, despite the current situation, and for using this platform. I think all of us have become a lot more familiar with it. This is my first time presenting, so hopefully I have no glitches. I am Bonnie Loomis. I'm Executive Director for the South Carolina Clean Energy Business Alliance. We are the state's clean energy trade group. We consider anything that's low carbon to be clean. So we do include natural gas and nuclear in our bucket of clean energy fuels. But we, over the last couple of years, have obviously focused more on renewable and grid technologies, energy storage, et cetera, than we have on either nuclear or natural gas. And I come to this organization, as I shared just a minute ago, I am an attorney in South Carolina. I've practiced privately. My majority of my career was in policy, lobbying, representing energy interests before the legislature, and then as well doing some regulatory work before the Public Service Commission. So that is where I come from. We have just a little bit of time to spend with each other today. And what I'm going to do is give another overview of the Act, Act 62. I know that y'all had a presentation in the fall from Darcy Jones with the State Energy Office. And so some of this may be a little bit of recap. I think I pulled her presentation and I tried to not repeat it. And honestly, from a personal perspective, the way I've bucketed some of the contents of Act 62 is a little different. So maybe that's helpful. Update on the status of the regulatory proceedings, share with you some dates of upcoming schema events for you to put on your calendar, and then open it up for any questions. As everyone recalls, Act 62 was adopted in May of last year, and it was adopted unanimously by the legislature, signed by the governor, and really it was a reaction to the increasingly diverse energy marketplace that we see in South Carolina. We see more participants, more perspectives, and more technology, and ever-changing technology than we have in the history of our state. So it's an ever-changing marketplace, and honestly, in a policy perspective that we produced or republished back in the spring of 2019, we indicated that we would be encouraging the legislature to put energy policy on their regular agenda of topics to address, much like the budget, much like education, much like healthcare. We are at a point in time where energy policy needs to be a common part of our policy discussions and debates, not every few years we'll do a solar bill. It needs to be an ongoing conversation, because the intent is to build on the positives that we've had. And that is one of the things that the legislature identified in the language of Act 62, build on the successful deployment of solar generating capacity that was created from Act 236. I take a little bit of issue with the fact that they used only the word solar. Kelly, I appreciate that in y'all's regulations, you are using renewable facility and not focusing just on solar. Act 62 the best way for me to think of it is changes that are for customer generators, changes for utilities, changes for the regulatory entities, and then changes for consumers. And the biggest changes for customer, well, not the biggest changes, the most immediate changes for customer generators as of the adoption of the Act was the addition of energy storage to the definition of customer generator that was adopted in Act 236 in 2014, the lifting of the cap on net metering and solar leasing, the non-residential solar leasing being allowed, and then the extension of one-to-one net metering. All of those changes I consider to have been inherent in the Act. They didn't require any activity at the Commission to implement those changes. As soon as the governor signed the bill, that was the law of the land, and those changes were effective. Customer generator changes that are required to go through some level of PSC litigation included streamlining small power producer rates and contracting, basically the PURPA interactions between the investor-owned utilities and small power producers. And then over time, it will be establishing a solar choice metering tariff. Those two are critical to the long-term implementation of Act 62. The streamlining of the small power producer rates and contracting terms is the case that the Public Service Commission started, I think it was within 60 days of the effective date of the Act. And most everyone may recall a lot of media attention around the Commission's initial order. This is the avoided cost methodology proceeding, and it also was the proceeding to set contract terms, 10 years or longer, 10 years or less. And so there was a lot of discussion from a public perspective once the PSC issued their initial directive back in the fall. There were petitions for rehearing on certain issues. These are separate dockets for each individual operating utility, and each of them are in different stages of rehearing or evaluation after the orders have been issued. The solar choice metering tariff docket has not yet, well, the docket's been open, but it's not active. So changes for the utilities included requiring them to offer a voluntary renewable energy program for commercial industrial customers, or customers with more than a megawatt of demand, and typically those are commercial industrial customers. And this is in some parlance around the Act being referred to as voluntary renewable energy programs. I tend to not want to use the word voluntary because I think it gets a little bit confused with the distributed energy resource programs that the utilities were voluntarily able to offer as a result of Act 236 back in 2014. This is not voluntary on the part of the utilities. This is a mandate. They have to offer a commercial industrial renewable energy program that allows customers to then voluntarily elect to participate and to choose with whom they participate in terms of the provision of their electric generating capacity. It also requires investor-owned utilities to evaluate all options, sort of an all-source option requirement for any new major generating facility. Those are any facilities above 75 megawatts. Our state for a long time has had what is referred to as the siting statute or the siting act, and a utility that plans to build a facility that is 75 megawatts or greater has to go through this siting proceeding. And so within that siting proceeding now will be an evaluation by the Public Service Commission of what other options for fuel source and generating capacity the IOU undertook prior to filing that siting facility act proceeding. So, I mean, that is really a pretty significant change for the utilities. While, you know, internally they may evaluate all options for new major facilities, the requirement that they now actually explain what that process was and do it within this proceeding is quite different. Another major change that affects the utilities is the integrated resource planning changes. They are required to submit them triennially, update them annually, publish them on their website. Those proceedings are subject to regulatory review and approval, which is brand new. The plans have always been required. They've been required on a different schedule, a longer schedule, and annual updates have not been required. So this is another really major change for how the utilities operate, and it will allow more ongoing routine conversation around energy policy through the choices that the utility company is making within those IRPs. It'll allow that conversation, which I think is a really great thing from an energy policy development perspective. The other thing that the Act required of the IRPs is that they include multiple future scenarios that have varying levels of both renewable and energy efficiency penetration. And that's a new requirement as well. Again, it's not like the utilities didn't include this type of penetration in the past, but in their IRPs, but this is requiring them to do it at multiple different levels and really kind of shines a light on it in a way that it hasn't statutorily and regulatorily been shown before. And then the Act encourages the IOUs to propose community solar programs. This is indeed one of those voluntary things. The utilities are not mandated to do it. There are also changes that affect the regulatory entities and consumers. Not necessarily, in terms of how the consumer thinks about their energy use and power provision on a daily basis, but they're still pretty dramatic. So the Public Service Commission is now required on their own to initiate a review of interconnection standards. This review does need to include energy storage. The review of the interconnection standards will allow a lot of discussion around timely processing of the interconnection request, which is something we know is sort of an ongoing source of consternation at times for some developers. And it really gives the commission broad latitude in what to look into in regard to those interconnection standards review proceedings. The commission's also required to promote solar energy programs for low and moderate income customers. That's sort of a new aspect of what the commission is charged with, to actually promote something. Initiate with the Office of Regulatory Staff. They're authorized to do this. They don't have to do this. We think that they will be doing this, an integration study to evaluate how we as a state can bring new and existing and new technologies into the grid in a way that is not disruptive and productive. And to open a docket to create programs for competitive procurement. This is a little novel for the commission as well. A big change for the Office of Regulatory Staff is that they no longer represent the consuming public. That is the role that the Department of Consumer Affairs has taken. They have an increased role in the IRP process. And one of the things that I failed to mention on the previous slide is that the IRP requirements in Act 62 do not only apply to the investor-owned utilities, they apply to all utilities in the state. And that's pretty dramatic and pretty bold change as well for us. And those utilities who do not fall within the jurisdiction of the Public Service Commission, they submit their IRPs directly to the Office of Regulatory Staff. Of course, the IOUs will submit theirs to the Public Service Commission. So there is this sort of triangular relationship now between the commission, ORS, and the utilities, all of the utilities, including the co-ops, in terms of resource planning and evaluation, which is so important as we as a state try to take advantage of new technologies, but do it in a way that respects the foundation that's been laid and really cared for quite effectively by the existing utility interests in the state. The Office of Regulatory Staff also has the ability to hire an independent evaluator to bring into the proceedings for the Siting Act proceedings for new major facilities. And then, as we just heard from Kelly to develop the renewable customer protection regulations. Again, Kelly, I appreciate y'all's use of the words renewable and not specific to solar. So you are indeed through that process, and then through a hearing of record in Public Service Commission matters, you are the agency that represents the consuming public interest. That's sort of a back to the future or return to the past sort of arrangement for consumer affairs. They used to be prior to some restructuring of the Public Service Commission and the creation of the Office of Regulatory Staff. The Department of Consumer Affairs was the consumer representative in energy or all proceedings before the Public Service Commission. And I decided to put here the Electric Utility Customer Bill of Rights that was contained in Act 62. It is not necessarily something that comes formally under the oversight of the Department of Consumer Affairs, but Act 62 for the first time ever articulated an Electric Utility Customer Bill of Rights that I believe that Consumer Affairs will probably point to as they represent consumers, especially in rate cases, because the Utility Customer Bill of Rights speaks to fair and reasonable rates in particular. So the PSC dockets that were required and permissible under Act 62, there's over 20 of these dockets. There is a separate one for each investor-owned utility, and then there are some that are generic, and it is extremely difficult right now to keep up with the status of all of these. So I want to say I have done my best to encapsulate it at a high level where these dockets are. I admit that there could be some errors here. I've checked with a couple of different attorneys who are active in these dockets. I feel like this is a fair representation, but it definitely does not get down into the weeds of each of these dockets and where each of them individually is, not only in terms of the subject matter, but in terms of the actual utility that it relates to. The small power producer rates and contracts is the one that I referenced earlier. It is active in post-hearing matters on specific subjects like the terms of the contracts. And right now is looking towards a fall for rehearing on some of those matters. The solar choice metering tariff, this is the docket that will be used to establish the rate for solar choice metering or net energy metering after the expiration of one-to-one net metering. So this is going to be a critical docket to watch going forward. It is open, it is active, there are filings being made, but it is not, I wouldn't say it's fully progressing at this point. The Public Service Commission is in the process of drafting regulations related to their hiring of independent consultants and experts for multiple dockets here. And so that's really, I think, what the next step in this docket will be. The commercial industrial renewable energy programs dockets are open and active, but again, they're sort of from a forward progress perspective going to be coming along behind the drafting and the promulgation of RFPs for consultants. The major facility siting. So what I did when I put my slide together here is I basically went to the slides that I created and I tried to pull the subject matters in order of how I discussed them. So it's a little, I didn't bucket all the open dockets together. I put them here in order of how I mentioned them. The major facility siting dockets will be opened as needed by the utilities. Those would be at the utilities initiative and only when they plan to develop a major generation facility. The integrated resource plan dockets are open and active. Again, they're in various stages of activity. Dominion's docket, however, has been slated for hearing in September of 2020. One of the interesting aspects that I didn't necessarily mention a minute ago of the IRP dockets is that they in the process of being reviewed and approved by the Public Service Commission, will now actively have interveners and stakeholder groups who are making comment and offering their own thoughts within those dockets. And that's a major change for our state, for the Public Service Commission. Community solar dockets are open. There's some discovery taking place, and I think one of them, and I can't remember which. Again, the filing for the draft regulation related to consultants is also a part of that docket. The interconnection standards dockets were opened and then they were administratively closed. I believe the reason they were administratively closed is to wait for this regulation to move through. The commission is definitely going to need the assistance of some experts in proceeding with the interconnection reviews. And then the integration study and competitive procurement dockets are remaining to be open. What I felt like would be extremely helpful to provide in particular is a link to the list of the dockets that was published by the Office of Regulatory Staff back in June of 2019. Again, there's more than 20 dockets here. They're all proceeding essentially at the same time, some a little faster than others. It's extremely difficult to keep up with where each of the proceedings are. So an important piece of information in attempting to determine where a proceeding is knowing what the docket number is. So you can find that on the Office of Regulatory Staff's list, and then you can take that docket number and use the search function on the Public Service Commission's docket management system, and it can bring you to the electronic file for that docket that then has multiple tabs that shows who the parties are, what the timeline is, a hearing schedule if there is one. It has all of the filings in date order. It is a great tool. So if you're interested in a particular utilities docket, refer back to the list on the Office of Regulatory Staff's website and then use that to go over to the commission and search for it directly. I also included a link to the text of Act 62. It's originally House Bill 3659, which is why you have this number over here for that. And then a couple of summaries that I thought were good summaries to pull that I referred to as I was refreshing myself. And then as well, I included the link to the Solar Council presentation from the fall, in case y'all are not aware how to find that, although I expect you are. And real quick, I know we're getting close on time here. The South Carolina Clean Energy Business Alliance produces 2 events annually that really are the core of our activities: Energy Policy Forum in the spring and our annual energy conference. And the Energy Policy Forum had previously been scheduled for May 20th. We're now looking to hold that on June 25th, which is the Wednesday. We are planning it as a webinar, although we're hoping to evaluate some appropriate level of in-person attendance closer to that date. So please mark a calendar for that and be on the lookout for notices in that regard. And then our annual conference will be November 5th in Columbia. That is a Thursday. We are more likely than not going to hold it again at the Darla Moore School of Business as we did last year. However, I'm a little concerned about space in that room, that big meeting room, and we may need to find a larger venue in order to spread people out a little bit more. And we last year initiated a continuing education seminar in conjunction with the conference. It was primarily focused on continuing legal education credits. We're hoping to expand that to other licensed professionals this year. That'll be on the Friday after the conference. And I will create a Solar Council discount code for all of our events that gives you member rates for those events. And it is SCSC 2020. It will be. I have not done that yet. We had one last year that was SCSC 2019. So just bear with me if you're going to take a look at registering for our policy forum, which I actually have not updated on Eventbrite yet, to June 25th. I will be going in a little bit later today to add that discount code. So maybe check in next week on that or after you see some communications from us. Information about our events can be found on our website, which is down here in the bottom left corner of this slide. And we also encourage you to sign up for our mailing or email distribution list on the landing page of our website is the function for that. And that's it. Thank you so much. I'm going to see how to go back to where I can.
So you click on the participants tab. Dan, your hand is still raised. Do you still have a question?
Oh, here I
Do you
am.
have a question for Bonnie? Or if not, you can lower your hand.
Yeah, I just see, the only hand I see, Elise, is Dan Keaton's as well. It looks like he's, Dan, are you, if you're talking there,
I've lowered my hand.
okay.
Okay.
We're all getting used to this new technology. I just like to do it like that.
Yeah. Well, if we don't have any questions for Bonnie, I want to thank everyone for joining us today. We are recording this. I'm going to try to post it on the website, and we will, if and when we get that up, I'll send out the link to all of the Solar Council membership. So if you haven't signed up for our email notices, please do. I am also going to try to send out a survey about this webinar. It'll be really short. I want to get a little bit of feedback, and particularly to find out if you found it informative and if it is worth us trying to continue this in a regular series. So with that, I'd like to thank everyone and have an excellent weekend.